The Lawyer's English Language Coursebook, published by Global Legal English Limited. Unit 1B, The Legal Profession. Unit Listening.
My name is Rob Jones and I'm a trainee with a law firm. I've always wanted to be a solicitor and I can't imagine doing any other job. I started working here at Taylor Wallace a year ago. Taylor Wallace is a global law firm with its headquarters in the City of London. I studied law at Manchester University, but I wanted to do my training contract in London because I'm interested in insolvency law and banking and I think the best positions with the top law firms are here. I think my parents were disappointed that I didn't become a barrister and work in chambers and wear a wig in court, but I wasn't interested in that at all. With this law firm, the 2-year training contract is divided into 4 periods. Each 6-month period is called a seat. My first seat was in the corporate department. That really just means dealing with companies and businesses. I was involved in meeting clients, drafting documents, and took part in some very high-value deals. Of course, I had lots of support from the experienced people working on my team. We call them the principals, but I was surprised at how much responsibility they gave me. My second seat was in the property department. This involved acting for clients who were buying and selling domestic and commercial property, much of it office buildings here in London. I was able to get some experience of conveyancing as well as a little landlord and tenant law when we dealt with rentals. Next, I will be moving into the intellectual property department. I'm really pleased about that as it covers quite a few different areas of law and can involve famous clients. At the moment, the department is dealing with a breach of copyright case for a famous musician. I hope to stay with Taylor Wallace when I qualify as a lawyer next year. In fact, I'm looking forward to being based in London for most of my legal career.
Exam exercise listening.
Good morning, everyone. My name is Helen Ray, and I'm a solicitor in a local law firm. I'm here today because I understand that some of you are interested in a career in law and would like to ask me some questions. I've been working as a solicitor for over 10 years now, so I'm probably in a good position to give you a bit of advice. Who would like to start?
I'll start if I may. I would like to ask about the training that you had to do to become a lawyer. I know that you have to go to university and do a law degree, but what happens next?
Well, let's make it clear. When you talk about training to become a lawyer, you are talking about 2 different professions. If you want to work as a lawyer, you must first of all choose whether you want to be a solicitor or a barrister. The training for each profession is different.
Really? I thought that both branches of the profession were required to do a law degree, and then barristers had to find a place in chambers, and solicitors had to do some training with a law firm.
Not exactly. It might surprise you to know that it's not actually a requirement in the UK for a lawyer to have a law degree. My degree is in economics, actually, although most of my colleagues in the office do have a degree in law. I studied economics for 3 years, and then I took a 1-year course at the same university, now called the Postgraduate Diploma in Law. It's a kind of conversion course to law for people with degrees in other subjects. It was a difficult year. It was very intensive, but very enjoyable too. I learned a lot.
So a law firm will be happy to employ me if I have a degree in psychology. That's a subject that I really would like to take, but I didn't think it would be possible if I want a career in law.
Yes, that's right. So long as you take the conversion course, you'll be okay. Law firms like diversity. It gives them people with a wide range of skills and knowledge.
That's interesting, but I want to take a law degree and become a lawyer in the traditional way. If someone wants to be a barrister, is a law degree the best qualification for them?
The usual route for both solicitors and barristers is to start with a law degree. The law degree in the UK is known as the LLB. This is the bachelor's degree in law. The master's degree is called the LLM. The LLB takes 3 years and is ideal for both solicitors and barristers. After that, the training and the exams are different for the 2 professions.
What do solicitors do after their first degree? Solicitors don't speak in court, so I suppose they don't need to learn how to do that, do they?
I'm not surprised that you have said that, because it's a common misconception that only barristers speak in court. But it's actually not true. Solicitors are required to do a year of practical training after their degree, and that training includes advocacy, which is the skill of speaking on behalf of a client in court. If you choose to be a solicitor, you will have to do this extra year of training at university. It's called the Legal Practice Course.
What skills do they teach on the course?
A whole range of things. As we've already said, advocacy. You need to be confident as a solicitor when speaking in court. You are taught how to draft documents correctly, some negotiation skills, and, of course, client interviewing. Being able to interview a client well is extremely important.
That all sounds good, but I have a worry about something. I'm not very good at maths. Will that be a problem?
Not really. The legal practice course does cover business management skills, and you will be tested on your ability to keep accounts. But that's something that you'll just have to learn if you really want to be a solicitor. I'm not very good at that side of things either, I'm afraid, but I soon got the hang of it.
And after the legal practice course, are you a qualified solicitor?
I'm afraid not. You still need to get a training contract with a law firm, and for many students, that's the difficult part. The truth is that our universities produce more law graduates than we need, so getting a training contract with a law firm is a competitive business. The training contract gives you 2 years of practical experience working as a solicitor. When the 2 years are completed, you are a qualified solicitor, and your name is added to the list of solicitors who are allowed to practice law, or, to give the list its correct name, the roll. The roll is kept at the headquarters of the Law Society of England and Wales, which is in London. And one more thing, remember, qualifying as a solicitor or as a barrister is expensive. The legal practice course currently costs around £7,000, so you will have to pay that on top of the cost of your degree. But don't let me put you off a career in law. I found my training very hard and very expensive, but I haven't regretted my choice of career at all.
Unit 2B, the language of banking and finance. Unit Listening.
Good morning, Miss Finch. Thank you for coming in to see us today. I understand you'd like to take out a loan.
Yes, that's right. I'd like to borrow £6,000.
OK, that shouldn't be a problem. I just need to go through the application form with you and get some information that we'll need to process your loan.
OK.
First of all, some general details. We need to confirm that you are a full-time resident in this country.
Yes, I live here in Chatsworth.
Good. And do you have a bank account?
Yes, my account is here with your bank. I've had it for about 4 years.
Great. And do you have a regular income?
Yes, I'm paid on the 26th of each month. My pay goes directly into my account.
Good. We just needed to be clear about those points before we start. Now, I've got the application form up on the screen. This should just take a few minutes and we can process your loan immediately. First of all, what is the loan for?
It's for home improvements, actually. I bought my house 2 years ago and it was fairly cheap because it was in a bad condition. I'd like to put in a new bathroom and a new kitchen, and I'd like to do something with the garden. It's in a bit of a bad state.
Home improvements. OK, that's fine. And what amount would you like to borrow? Did you say 10,000?
No, just 6,000.
That doesn't seem much for the list of jobs you've mentioned. Will it cover everything you have in mind? Our interest rate is very good at the moment, so you could probably go a little higher if you needed to.
No, 6 will be fine. I've got quotes for everything from the builder, and 6 covers it.
Fine. You can always apply for more later on if you find that you need it. And what repayment period would you like? You can make your repayments over 24, 36, 60 or 120 months. That will affect the amount of the monthly repayment, of course. The payments will be considerably bigger over a shorter period of time.
I'd like to repay it over 5 years if I can. So that would be 60.
Good, 60 it is. Now we move on to personal details. Are you Miss or Mrs?
Actually, I'm Ms. Do you have that title on the form?
Yes, we do. Ms. And your first name, please?
Alison.
And your surname?
Finch.
Any middle name?
No, just plain Alison.
Good, that's nice and easy. And your date of birth, please, Miss Finch?
6th of January 1979.
OK. And do you have an email address?
It's alison.finch79@hotmail.com.
So there's a dot between the Alison and the Finch.
Yes, that's right.
Thanks. And your marital status, please, Alison?
I'm divorced. I've been divorced for 2 years now.
OK. Any dependent children?
Yes, one. I've got a little girl.
So you're making this application by yourself? There's no other applicant?
That's right.
Have you been known by any other name over the last 5 years, Alison?
No, Finch is my maiden name. I didn't change it when I got married. I've always been Alison Finch.
OK. And now it's just contact details. You own your own house, don't you? So you're not a tenant. How long have you been at your current address?
2 years and 1 month.
And your house number, please?
Number 39.
And your postcode?
CH5 9QJ.
CH5 9QJ. Right. The computer is saying 39 Bellevue Avenue, Chatsworth. Is that your address?
Yes, that's right.
Good. We're nearly done. The last thing is your telephone number. Do you have a home telephone?
Yes, I do. But it's on the blink at the moment, actually. They're coming to look at it this afternoon. So you're better getting me on my mobile if you need to speak to me today. Anyway, my landline number is 0771 for Chatsworth, then 6520309.
Thanks. And your mobile? We shouldn't need it, but just in case.
0899 167 0325.
Thank you. Well, that's all the info we need for the first page. Now for the next page.
Exam exercise listening.
Good morning. It's 7 a.m. and you're listening to Central Radio, the radio station with the latest news and travel information for Central London this Thursday morning. This is Karen Malloy with our weekly look at money and finance in the Thursday Money programme. Today's celebrity guest is that well-known actress from the town of Westborough and London resident Julie Barry. Good morning, Julie, and welcome to Central Radio.
Good morning, Karen. It's nice to be here.
It's great to have you as a guest on the Money programme, Julie. Now, let's start at the very beginning of your financial life. You were born in Westborough in the north of England, and your first job was at a local theatre. How much was your first salary?
You couldn't really call it a salary, Karen, because I only worked 1 day a week, and I was paid every Friday. When I was 17, I was still at college, but I got a Saturday job at the local theatre. I was an assistant to the stage manager, which was marvellous because I was being paid for doing something that I loved. The pay was £4 a week, which I thought was a lot of money. I got it cash in hand, which would be unusual these days. I saved £2 a week by giving it to my dad to put into his bank account for me, and the rest I spent. I was quite sensible with money as a young person, but less so now, unfortunately. These days, if I see something I want, I usually buy it.
And where did you open your first bank account? You're on TV all the time these days advertising the Glen Royal Bank. So does that relationship go back to your early days as a saver?
My first current account was actually with the London National Bank. My local branch was in the centre of London, in a street very near Trafalgar Square. It's not there anymore. I walked past it the other day and the building is now a nightclub. The bank has closed most of its London branches because people do so much internet banking and telephone banking these days. It's a shame. It was handy for my drama school in Shaftesbury Avenue. I used to go in and draw out £20 every Friday in the company of city businessmen. It made me feel very rich and important, even though I wasn't at all. We had to go into the bank and queue to withdraw money in those days. It was in the 1970s, long before ATMs were around, which makes me feel very old. Most of the £20 was spent on rent. After paying the rent, I had about £4 left to live on for the week.
Did you run up an overdraft? Most students do.
Unfortunately, yes. When I got my first real acting job in the late 1970s, I was quite badly in debt as a drama student. I had a loan of £3,000, which I was paying off in instalments. I seem to remember they were £25 a month, which was a lot. I also had an overdraft. My limit was £100, so my overdraft stood at £100 most of the time, I think. On one occasion, I got a nasty letter from the bank because I'd exceeded my limit by £11. I never seemed to have any money.
Not for long, though. You got your first acting job in London at the age of 21, didn't you? Your financial situation must have improved somewhat.
Yes, it did. I got the part of Juliet in a production of Romeo and Juliet, and suddenly I earned a lot more money. That must have been in 1978, the year I opened my first savings account. It was with the Glen Royal Bank. I chose them because their interest rates were very good, and I opened a high-interest account. I was saving for a house in London because the cost of renting was disgraceful, even in those days. I opened a savings account to get together the deposit I needed to buy the house, which was £2,500. It was hard, but I think it's even harder now. I don't know how young people can afford to live in London at all, with prices the way they are.
And did you save enough money to get your house in London?
Indeed I did. I still live in the house that I bought in 1983 in Notting Hill. I got my mortgage from the Glen Royal Bank. It was for £75,000, which I thought was a fortune at the time. The interest rate was fixed at about 5%, as I remember, for the first 5 years. After that, it was going to go up. Luckily, I got a part in a film in Hollywood in 1987, and I was able to pay off my mortgage completely.
That must have been a relief to you. Paying the mortgage is most people's major financial worry. And how about saving for your retirement? Do you have a lot of money for your old age, or do you plan to work forever?
I plan to keep on working for as long as I'm offered acting roles, so I hope to keep on earning money for some time yet. I've invested in property all my life, so that is my security for my old age. I plan to keep my house in London, but I have 2 houses in France and 1 by the sea in Brighton, so I can sell all 3 houses if I need to.
I see. And how about your financial behaviour these days? Do you have a credit card, for instance?
I have an American Express card. I cut all my other credit cards up because the interest rates on them are so high. I also use my debit cards a lot instead of carrying cash with me. I don't think it's safe for women to carry cash in big cities nowadays. I was mugged in New York a few years ago, so now I tend not to have more than £10 in my purse. I have a son, Jason, who is 18 this year. I used to keep money at home in case he needed it, but now that he's 18, I just transfer it into his bank account. I normally do that using my bank's internet banking service. It's marvellous. I often do my banking at 2 a.m. when I can't sleep.
Yes, I think a lot of people do. And one final question, Julie. What's been your best purchase up until now? The best thing you've ever bought?
I would say a work of modern art that I bought from an exhibition at Goldsmiths College in London. I had no money at the time, and I had to borrow £60 from my parents to buy the painting. It took me 2 years to pay them back, although luckily they were kind to me and they didn't charge me interest. The painting is insured for £1 million now. That was definitely my best financial move ever.
Julie Barry, thank you very much.
Thank you.
Unit 3B, the language of contract law. Unit Listening.
The subject of today's lecture is contract law and the different forms that a contract can take. Not all contracts are alike. In the UK legal system and in the USA, a legally binding contract can be created in several different ways. For example, a contract can be either oral or written. Most legal systems around the world accept the idea that a spoken agreement can be as valid as a written agreement. There is a third way to create a contract, and that is in the form of a deed. Once we've established the form that a contract might take, we need to consider its scope. Contracts can be unilateral or bilateral in nature, creating quite different obligations for the parties concerned. All of these points require some explanation. Let's begin with oral contracts. An oral contract is a spoken agreement. In most cases, it's just as valid as a contract in writing. I am often asked if an oral contract would be binding if it were for a huge amount of consideration, let's say £1 million. The answer is yes, it would be binding. It doesn't matter if a contract involves a large amount of money or not. A spoken contract is equally as binding upon the parties as a written one. One of the most famous cases in this area of law is from the United States. In December 1983, a Texas company called Pennzoil agreed to buy another company called Getty Oil. The deal was done with a handshake, but no contract was signed between the two companies. Pennzoil then announced the acquisition of Getty Oil. However, a few weeks later, a third oil company called Texaco announced that it had bought Getty Oil. Remember, no written contract had ever been signed to say that Pennzoil had already bought Getty Oil. It seems that the people at Getty Oil felt that a handshake wasn't enough to seal such an important deal. However, when Pennzoil successfully sued on the grounds that Texaco had interfered in a legally binding contract, they were awarded $10.6 billion in damages. This case shows that it would be a serious mistake to think that because there is no written agreement, then there is no contract. To move on now to written contracts. They have been in use since the time of the Romans, and with good reason. A written contract helps avoid disputes. When you have a written contract, both sides know the subject matter, terms and conditions of their transaction. A written contract is usually very detailed, but will generally include basic information such as the parties' names, the parties' obligations, anything that might happen that will excuse performance of the contract, and the result of a failure of one of the parties to perform. This is the most common type of contract and the one that you will come across most often in your professional lives. If we now look at deeds, a deed is a contract that must be in written form in order to be legally valid. It usually grants a right to do something or to have something. A deed used to need a seal. often made from red wax, to make it valid, but these days a signature is usually enough. Any contract for the sale of land must take the form of a deed. And finally, we must consider whether a contract is bilateral or unilateral. The more common of the two is a bilateral contract. This is an agreement in which each of the parties to the contract makes a promise to the other party. For example, in a contract for the sale of a car, the buyer promises to pay the seller in exchange for the seller's promise to give ownership of the car. In a unilateral contract, only one party to the contract makes a promise. A typical example is the reward contract. Anna promises to pay a reward to Kit if Kit finds Anna's dog. Kit is not obliged to find the dog, but Anna is obliged to pay the reward if Kit does find the dog. You will need to read about the formation of contracts in your textbooks in time for tomorrow's seminar. Please look at pages 335 to 387 and be prepared to answer questions on this subject tomorrow. Thank you.
Exam exercise listening.
Good morning, everyone. The topic of today's seminar is consideration in contract law. I hope that everyone's read the relevant cases in your textbook. I asked you to read the 25 pages up to page 285. Let's begin with a simple question. Can someone please name the essential elements of a contract according to English law?
Intention to create a legal relationship, offer, acceptance, and consideration.
Good! To make a valid contract, all of those things must be present. Over the past few weeks, we've looked at 3 of those elements. Today, we will look at consideration. Let me start by asking you to listen to the story of a dispute between 2 parties. Mr. Brown is worried about the environment. He is afraid that pollution and global warming are destroying our planet. Therefore, he decides to do something about his worries. He decides to hold an event to publicise the problem. He calls the event Save the Planet Day. He decides to hold his event in St James's Park near his home in London on the 5th of April. He contacts a marketing company in Manchester. The name of the marketing company is Selfast UK. Their job is to advertise the event and to attract companies to attend. Mr. Brown has a telephone conversation with Selfast UK. The manager of Selfast UK tells Mr. Brown that the cost of promoting the event is £5,000. Mr. Brown agrees to pay this and pays a deposit of £500 by credit card over the phone. So, a contract now exists between Mr. Brown and Selfast UK. Am I correct?
Yes. All of the elements of a contract are present. One of the parties is a business. So according to case law, a court will assume that there was an automatic intention to create a legal relationship.
And there was clear offer and acceptance. The parties are clear as to the terms of the contract, and they have both agreed to them.
And consideration?
Yes, there has been an exchange of consideration. Mr. Brown has agreed to pay a certain price, and Selfast UK has agreed to carry out a service in return. Therefore, the parties have a contract.
Good. Let's move on and complicate the situation a little. Let's say that Selfast UK does the job very well. Hundreds of people have promised to come to the event, including a few big companies. The best news is that a major catering company called the Ethical Food Company is considering providing free food for everyone who comes to the event. Mr. Brown is delighted. He phones the manager of Selfast UK a week before the event. He tells the manager that he's so pleased with the way that things are going that he will pay a bonus of £1,000 if Selfast UK can persuade the ethical food company to come to the event. Now, Mr. Brown has promised extra consideration to Selfast UK, hasn't he? A potentially complicated situation for the parties, I'm sure you'll agree. Now, sure enough, Selfast UK persuades the ethical food company to come to the event. The manager of Selfast UK claims his £1,000. Mr. Brown refuses. He says his original payment covers everything. Is Mr. Brown contractually obliged to pay the extra money?
I'm not sure. There are several relevant cases on this subject, and I don't know which one applies.
Imagine Selfast UK is your client. The manager wants the extra £1,000 he was promised. Would you advise him to sue? As you know, a court is obliged to refer to case law. What is the relevant precedent case for a situation such as this?
I think the relevant case might be Stilk and Myrick. The principle of law seems to be the same.
Good. Go on. You are on the right track.
In the case of Stilk and Myrick, some English sailors brought a claim against their employer. The facts of the case were that when a ship was at sea, several sailors deserted. They just left the ship without permission. I think the year was 1809. It was a long time ago. The captain of the ship panicked about getting back to England with so few men on board to do the necessary work. He promised the remaining sailors that if they would take the ship safely home, they would receive a bonus as well as their normal pay. In fact, I think he promised to divide the wages of the deserting sailors between the sailors who stayed. The sailors agreed and expected to receive a bonus upon their return to England.
That's right. And upon their return, of course, the captain broke his promise. He told the sailors that they were paid to work on the ship and that they should not expect extra payment for carrying out their contractual duties.
That seems unfair. I see both points of view, but a promise is a promise. I think the court should have enforced the captain's promise to pay the men.
Well, the court of 1809 disagreed with you. One of the sailors sued. It was held that the sailors had provided no consideration for the extra payment. They had simply performed the duties that they agreed to carry out under the original contract. So, if we decide that Stilk and Myrick is the relevant case, and we follow the principle of law that it laid down, then Mr. Brown will not be obliged to pay the £1,000 bonus to Selfast UK.
But I don't think it is the relevant case in this situation. There is a much more recent precedent from 1991 that says if the defendants in a situation like this have received a real benefit, then the extra payment will be enforceable. I don't think Stilk and Myrick really applies here.
The name of the more recent case, please?
The claimant was called Williams. Is it Williams and Roffey?
Good. Go on. Why is that case relevant?
Because the judge held that, so long as there was no duress or threat for the extra payment, and that the offer of extra money was made willingly and voluntarily, the extra benefit one of the parties receives, in our case the attendance of the ethical food company, should be paid for with extra consideration from the other side. I think Selfast UK would be successful if they sued Mr. Brown. If I were their solicitor, I would cite Williams and Roffey.
Agreed. Well done. That is a good example of finding the correct precedents to support your client's case. Now, let's move on to the next situation.
Unit 4B, the language of employment law. Unit Listening.
Good morning, ladies and gentlemen. First of all, thank you very much for coming along to this breakfast seminar at Freeman Smith this morning. You're all very welcome. My name is Paul Hollingsworth, and as most of you know, I'm a partner in the Employment Law Department here at Freeman Smith. The subject of this morning's talk is the Age Discrimination Act, a new Act of Parliament that came into force a few days ago on the 1st of October. This new legislation will affect all of you as employers, and one of the key messages that I have for you today is the importance of complying with it in order to avoid being taken to employment tribunals by unhappy employees. From now on, you should be very aware of how you treat employees with regard to their age. The new regulations will have an impact on every aspect of a company's employment policies, including pay and benefits, promotion, dismissal, redundancy and retirement, and even training opportunities. It might surprise you to learn that one of the most important areas for you to consider as employers is the language that you use in advertising job vacancies. When you are looking for new staff, you have to be very aware of the words you use in any newspaper or internet advertisement, as well as in any internal memo you might write advertising a new or vacant position within the company. To use another country's experiences as a guide for us here in the UK, our neighbours in the Republic of Ireland introduced legislation 6 years ago to prevent employers discriminating against employees on grounds of age. Our research on how things have worked out in Ireland is interesting. It tells us that most claims in tribunals have been based on discriminatory advertising rather than discrimination in the workplace. In other words, too many employers are using discriminatory language in the recruitment process. So, what do you need to be aware of when you advertise a job? Well, first you should remember not to use certain words in your advert that suggest you only want people of a certain age. You might, for example, face legal action from older people if you advertise for a young, dynamic graduate to fill a position in your company. These words, young and dynamic, have been interpreted as automatically excluding older people. On the other hand, be careful of words such as senior, mature, or well-experienced, as they could be seen as excluding younger people from applying. As well as being careful about the words that you use, you also need to be careful about making general statements in job adverts. For example, requiring that all applicants for a particular job have a degree, if it is not really necessary to do so, might be seen as discriminating against older people. This is because younger people are more likely to have had the benefit of a university education. Just to make local employers here in Chatsworth fully aware of the situation, I have with me a copy of Thursday's edition of our local newspaper, the Chatsworth Herald. As you all know, the Herald carries a jobs vacant section every Thursday. It might come as a shock to you to discover that approximately 25% of all the adverts in the newspaper this week breached the new legislation. That means that all of these advertisers are open to claims from potential employees who might feel that they have been discriminated against on grounds of age. Now let's move on to employees who are currently working for you. A case was brought against an employer in Ireland last year by a female employee aged 61. Her name is Brenda Flanagan. Brenda worked in the accounts department of a large chemical company, and there is a normal retirement age of 65 for people in her position. This particular lady did not wish to retire at 65 and intended to make a request to continue working when she received notice of her retirement. The employer arranged a 2-day training course for everyone in Brenda's department on a new software package that they're going to use. The employer told Brenda that she would not be trained because she was retiring soon, and it wasn't worth spending the money on training her. Brenda took legal action against her employer immediately. Another age-related case was brought on quite different grounds. Michael, aged 55, worked in an office where most of the rest of the staff were aged 25 to 40. Everyone in the office, including the manager, often met for drinks on Friday evenings, but they didn't ask Michael to join them. Michael discovered that they discussed work issues on those nights out, and he felt undervalued and excluded. In both cases above, Brenda and Michael were successful at tribunals. Both successfully argued that they had suffered from age discrimination at work. I cannot stress to you strongly enough how important it is to be aware of the new regulations and not to suffer financially because of the compensation payments to employees. I prepared a fact sheet for you to collect at the end of the seminar, but we will now have a question and answer session based on new legislation. Thank you.
Exam exercise listening.
Good afternoon, Mr. Winter. Please take a seat.
Thank you.
How can I help you today? I understand that you have filed a claim with an employment tribunal. Is that right?
Yes, I filed a claim a couple of days ago for unfair dismissal against my employer. I was an officer with the West Midlands Police Force. I used to work mostly in the centre of Birmingham. They sacked me 2 weeks ago.
Oh dear, I'm sorry to hear that. On what grounds?
They sacked me on the grounds of my attendance record. I've been off work a lot the last few years. I don't argue with that. They said I'd taken 770 days sick over the last 4 years, which is probably true. I hadn't bothered to count the days, to be honest with you.
That's an awful lot of time to be off work sick. Why was that?
Well, that's the unfair part. I was very badly injured when I was on duty in June 4 years ago. My colleague and I were called to a house in Birmingham late one night where there was a domestic dispute. It turned out to be a very serious argument between a husband and a wife. I was kicked in the head by the man of the house during the course of the incident. I lost my hearing in my left ear for months. It's still not completely better yet.
I see. That sounds terrible. So you would agree that you have had a lot of time away from work because you were ill, but you would say in your defence that it's all due to an incident that happened at work. And on the basis of those facts, you claim your dismissal is unfair.
Precisely. They are firing me for something that's not my fault. Surely they can't do this to me.
Well, let's see, shall we? It depends on what procedures were followed and what the facts of the case are following the attack upon you 4 years ago. Let's start at the beginning. You say you were injured at work in June of that year.
Yes, that's right. The attack left me partially deaf.
Any other injuries? Any broken bones?
No, just bruising to my face. The main problem was with my ear.
I see. And did that improve? Did your hearing return?
Yes, it did. After about 6 months, my hearing was much improved. But being away from work had left me suffering from depression. I was alone at home day after day with nothing to do. I became very miserable, and I had to return to the doctor for antidepressant tablets.
But your initial injury was better. The injury to your ear. Am I right in saying that?
It wasn't completely better, but the doctor said despite that I was fit to return to work after 6 months, yes. It was my psychological condition, not my physical condition, that left me unable to work.
I see. And what did your employer have to say about that?
My supervisor was a woman called Ros Shannon. She was extremely unreasonable, not very sympathetic to say the least. She told me after I'd been absent for a year that she was doing all she could to help me, and that I had another 12 months to improve my attendance record. She said that as long as I was employed, she couldn't recruit anyone to replace me, and my colleagues needed help. It was horrible. I was made to feel very guilty.
There's a good chance that she will say exactly that at the tribunal. It's a fair point to make that they couldn't do without you for too long, especially once you had recovered from your initial injury. I'm afraid that some employers are not too sympathetic about depression and believe that going back to work is the best solution to the problem.
That's exactly the attitude she had. She wrote me a letter last week saying that she would file a defence saying I had only managed to work for 6 weeks in the last 4 years and that I refused to return to work.
And is that true? Have you only worked for 6 weeks since the attack?
Yes, I was recovering from the attack at work and became depressed. Then my closest friend moved away to Australia and that made me worse. My mother became very ill. Everything seemed to be too much for me. They offered me the chance to go back on a part-time basis at first, but I couldn't even manage that.
I see. Well, Mr. Winter, if your employer has followed the correct procedures and has tried to support you in your return to work, I don't really think you have much chance of success. You will have to convince the tribunal that your employer has acted unreasonably, and I'm not sure that that's true in this case.
Really? So you agree with them?
Not at all. You have my full sympathy. But I'm afraid the tribunal has to be realistic. On the basis of what you told me today, I would advise you to think again before proceeding with your claim.
I see. Yeah, I'll think about it. Thank you.
Unit 5B, The Language of the Law of Tort. Unit Listening.
Today's lecture is a general introduction to the law of tort. First of all, let's ask ourselves, what are the aims of this area of law? Why do we need to have a law of tort, or as some people call it, the law of obligations at all? Those are questions that really require a lengthy answer because the law of tort covers so many different situations in life. On a very general level, however, we can say that the law of tort is concerned with the idea of redress. Students often ask me for a precise definition of redress because it's not a word that you hear used in the street every day. I would say that redress means to remedy a wrong, to restore the balance of things. A person who has suffered a wrong wants to be put back in the situation that they were in before. A member of the public will usually describe this as a process of compensation rather than redress. This is probably because the claimant, in the vast majority of tort actions that come before the courts, is seeking monetary compensation for the wrong that he or she has suffered. To those in the legal profession, this monetary compensation is more correctly known as damages. So please don't confuse the two terms. Redress and compensation are quite different things. Let's stick with the idea of redress for a moment. We've established that monetary compensation is one type of redress. What else can the courts offer to the injured party? Well, in many cases, the claimant is not seeking money at all, but an injunction to prevent the occurrence of harm in the future. If we take as an example a case of the tort of nuisance, which is the tort of interfering with an individual's enjoyment of his or her land, you can clearly see that the defendant is engaged in a continuing act. Let's say the nuisance is one of noise. Damages are available to the defendant, but are clearly not the desired remedy for a claimant who is suffering over a long period of time. The claimant wants the nuisance to stop, and the obvious remedy is therefore injunction. So, having established that the law of tort is concerned with the redress and that this redress can take several forms, let's now turn to the question of liability in tort. We would correctly term this tortious liability. What is the scope of this liability in our legal system? It is absolutely impossible for every act in society that causes harm to another to lead the victim to demand a remedy. If, for example, I start a business such as a cafe in an area where there is already a cafe, and I provide a better service, then I have caused my competitor to suffer a loss. But should I be liable for that loss? Of course not. No reasonable person would suggest otherwise. So it is therefore a fairly easy matter to establish that not all losses or harm that a person suffers can be remedied. In general, the scope of tortious liability is as follows. The law says that I have an automatic duty of care towards other people in general. It doesn't matter who they are or whether or not I have any kind of relationship with them. I nevertheless have a civil duty not to harm them in any way. I am not allowed by law to hurt another person physically or to harm their reputation. This duty is independent of any kind of contractual agreement. The duty exists in the law itself and does not depend on the consent of the parties as it does in the law of contract. To give you an example, the law of tort says that I have an automatic duty not to trespass on your land. An automatic duty. The duty exists because the law says so and not because I have made any private agreement with you to undertake such a duty. Of course, in practical terms, there is often an overlap in any real-life situation between the law of contract and the law of tort. If we take the example of a company supplying a defective product to a group of consumers, this may result in concurrent liability in contract and tort. In other words, the company may be liable in both areas of law at the same time. The claimant may not, of course, recover damages twice. Similarly, tort and crime overlap. There are some torts that are also crimes, sometimes with the same names in both areas of law. For example, assault. Assault is both a crime and a tort. In some cases, the evidence from a criminal trial is used in a later civil action based on the same offence. Let's look at a criminal case involving a road traffic accident, for example. The state will bring a criminal prosecution if the driver of a vehicle caused an accident and he or she was breaking the criminal law. The evidence from the criminal case may then later be used as evidence of negligence in civil proceedings. The conclusion is to look at the law of tort as part of the wider law. Some legal commentators have somewhat unfairly termed it as the dustbin or the garbage can of the law of obligations. They mean it is there simply to deal with cases that other, longer established areas of law cannot deal with. I disagree. The law of tort exists for good reason, and it is an essential area of expertise for the modern lawyer.
Exam exercise listening.
Good afternoon, Mr. Kelly. Please take a seat.
Thank you.
I will need to take a few details about you in a moment, as you are a new client. You seem very upset. How can I help you today?
Yes, I am very upset. I was told by a good friend of mine that you are an excellent libel lawyer, Miss Ray. I hope you can help me because my life has been absolutely destroyed by untrue rumours. My wife and I have even thought about moving to France to get away from it all. It's been a terrible time for us.
Oh dear, I'm very sorry to hear that, Mr. Kelly. We do have a good reputation for our work on defamation cases at this firm. I'm sure we can help you. Would you tell me a few details about what has happened to you?
Certainly. The rumours started on the internet. Have you heard of a website called friendsagain.com? It's a website where people can get back in touch with their old school friends.
Yes, I know of it. I think most people have heard about that website. When you join the website, you can chat to old school friends, am I correct?
Yes, that's the one. I'm not a member myself, but I was a teacher at St Bernadette School in Middleton between 1975 and 1990. I'm retired now, of course.
I see. Please go on.
Well, as you can imagine, I've taught thousands of pupils in my time. I was a modern languages teacher, mostly French and German, you know. I'm afraid I was a strong disciplinarian. I was strict with my pupils, but they usually got good exam results. But I wasn't very popular with some of the kids. In fact, one of my worst behaved pupils, Gary Hetherington, was expelled from the school. That must have been in 1980 or 81. I was present at a meeting with him and his parents, and I insisted that he would not be allowed back into my class. He brought a knife to school, which was totally unacceptable. I had a terrible row with the boy's father at that meeting. He said that his son was a good lad and that I was victimising him. They insisted that the boy had the knife only because he was going fishing after school. It was a nasty business. The father was outraged about it, but luckily the headmistress agreed with me. The boy was ordered out of the school without taking any of his final exams. I believe he works as a window cleaner these days.
And has this story been mentioned on the website? Because if a story is true, you know, we can't usually defend it. What happened may have been unpleasant, but if the facts are correct, then there's probably not much we can do.
No, not at all. This story hasn't been mentioned, but Gary Hetherington is a member of the Friends Again website, and he has written a lot about me that is most definitely not true.
Has he really? That's a different matter. Can you tell me what's been written?
Actually, I've printed off his comments. I can email them as well if you like. Here. It fits onto one sheet of paper, but it's devastating nonetheless.
Thank you. So he says, does anyone remember that miserable, boring Kelly, the big fat idiot that taught us French? Did you know that he was thrown out of the school in 1990? The headmistress found out that he was having an affair with one of his 16-year-old pupils and fired him immediately.
That's exactly what he says. Of course I retired in 1990. Everyone who was at the school at that time knows that. But the people reading that website clearly don't know that. People keep on sympathising with my wife. An old friend of ours rang from Australia last week to say how sorry he was. I feel that I can't hold my head up in this town at all. Is there anything we can do?
Yes, there is. There's a very recent precedent in English law that helps us enormously with your situation. In 2002, a very similar case came before the County Court in Lincoln. A teacher named Jim Murray had been libelled by a former pupil on a very similar website to this one. In fact, the defendant in that case, strangely enough, is now a teacher himself. So it was pretty unbelievable that he could have made such stupid remarks.
You mean this has happened before and the teacher sued?
Precisely, on the grounds that he was the victim of a serious defamation. And he won. The court ordered the libellous comments to be removed immediately, and the defendant was ordered to pay £1,250 in damages and costs of £150. Of course, the local newspaper ran the story, and everyone in the town could see that the teacher was the victim of a libel.
Can we start action immediately? The sooner that this is over, the better.
I have a feeling we won't need to. We'll make some inquiries to find out who the internet service provider is who hosts the website. We'll write to them and to Mr. Hetherington and say that if the defamatory comments are removed immediately and there is a public apology, then we will be willing to settle out of court.
Let's do that then. Could you start the process today? I'm not interested in the damages so much as making sure my good reputation is restored. If we can get some money out of him, I'll donate all of it to charity. Then I'll have a much needed holiday. I'd like my legal costs to be covered though. I don't see why I should have to pay for his stupidity.
Certainly. And don't worry about this. The law in the UK says that once an internet service provider is aware of a defamation, they have a legal duty to remove it immediately. If they don't remove it within a reasonable period of time, they too can be liable for damages. That rule was established in this country as long ago as 1996. I imagine the service provider will insist that it's removed pretty quickly once they receive our letter, which will hopefully be within a day or two.
Thank you, Miss Ray. You have no idea what a relief this is to me.
Don't worry, Mr. Kelly. We're here to help. Let's get some details from you and we can get the ball rolling.
Unit 7B, The Language of Business Law. Unit Listening.
Good morning, Mr. Craig. I've got all the documents we need here to set up your company. I'll go through them with you and we'll fill them in now. Then you'll be able to sign them. First of all, we must complete this form. It's called Form 10, and it gives information about the first directors of the company. First of all, the company name. It's Outland Adventures, isn't it?
Well, that was the name we were using up to yesterday. But Shane, who is the other person who's setting up this company with me, and I, have decided that we want to call it Outback Adventures, to show that we're specialising in trips to Australia.
I see. So, what we've got to do now is check that the name is available for you.
How do we do that?
Oh, it's an easy procedure. We search the register of names to see if the name is already being used. If it is, you won't be able to use it. We can make a search online. Here we are. I'm putting in your proposed name. Yes, that's available. Good. Let me write that on Form 10. Outback Adventures Ltd.
Why have you added Ltd on the end of the name?
Ltd stands for limited. If you're setting up a private limited company, as you are, then by law the name of the company must end either with the word limited or the abbreviation Ltd.
I see. What's next?
I need your registered office address. The registered office is the place where all official documents will be sent. For example, tax documents, and communications from Companies House. Also, if someone sues the company, he or she can send the claim form to the registered office.
I'll use my home address. It's 15 London Road, Oxton, Hampshire.
Hampshire is Hapshire.
Exactly.
And the postcode?
OX5 4HJ.
OK. The next section is only used if an agent is acting for you, so we don't need to complete it. Next are the contact details. You can choose if you want to complete this or not. It's so that if the staff at Companies House have any questions about the form, they know who to contact.
OK, put my name, Peter Craig, and my phone number, which is 01482 685 341. Then I see the form has a space for DX number. What does DX mean?
That means document exchange. It's a special type of postal service. Instead of sending letters by the normal postal service, law firms usually use DX. It's quicker and usually cheaper than the ordinary post. I'll leave it blank as it doesn't affect you. Now, the company secretary.
That's going to be Shane's sister. She works for a big finance company. She's called Alice Bradman. No, wait, that was her maiden name. She got married last year. Now she's... let me think. Ah, yes, Baker. I've got her address written down. Here you are, 64 Green Lane, Letford. That's with a double T, Lettford. That's also in Hampshire. Postcode is OX373FS.
And does she prefer Mrs. or Ms?
Better put Ms.
And when will Ms. Baker be able to sign the form?
She'll be coming in to sign it with Shane at lunchtime today.
Good. Right, the last thing we need is the director's details. I understand that you and Shane will be the directors. Shane's surname is Bradman, isn't it? We have to list the directors in alphabetical order, so Shane's details need to go first. It's Shane, spelt S-H-A-N-E, and Bradman, spelt B-R-A-D-M-A-N, isn't it?
Yep. He doesn't have a middle name. He's actually a doctor. He did a PhD degree in ecotourism.
Right. And his address?
87 Hunts Road, Oxton, Hampshire, OX2 6GP.
And what's his date of birth?
14th of July, 1979.
And his nationality?
Oh, he's an Aussie.
OK, just let me write that. There. Australian. And his business occupation is?
Put down travel consultant.
And finally, has he been a director of any other company in the last 5 years?
No.
Thank you. Now, I need your details, Mr. Craig. I've got your name and address.
Yes, except my middle name. That's Robert.
And your birthday?
21st of November, 1978.
And your nationality is British?
Yes.
Now, we have to complete your business occupation.
Oh, put managing director. That sounds very important.
Right. And have you been a director of any other company within the past 5 years, Mr. Craig?
No.
Great. That's all done. All it needs for you is to sign just here. And here, where it says signed by the subscribers. The subscribers are the first shareholders of the company. Good. And Shane and his sister can sign it when they come in.
Exam exercise listening.
My name is Paul Evans. I was made redundant 12 months ago. I was very upset when it happened, as I had worked for the company for 15 years. However, I got a good redundancy package, and this meant that I could survive for 24 months without an income. I decided I would turn this into a positive experience and do what I have always wanted to do, which is to become my own boss. I decided to set up a business sourcing and selling goods from Asia and Africa. Not all types of goods, but concentrating on art, paintings, textiles and sculptures in particular. All of my business is done online. I have travelled extensively all over the world and have made a lot of really good contacts. So I thought I could successfully combine this with my computer skills. Also, working with the internet meant I could work from home without a lot of additional funding. I considered the type of structure that would be best for my business and decided to set up a private limited company. I wanted to give the impression that it was a bigger business than just me working in the spare bedroom. By being a private limited company, I can sign myself as director on all my correspondence with customers and suppliers. People's perceptions are really important. I thought about buying an off-the-shelf company from a company formation agent, but in the end I decided to see a lawyer because I don't know anything about the law involved in setting up a company, and I wanted to make sure everything was done properly. I also wanted to make sure the company was set up exactly for our purposes. The lawyer acting for us did a great job and said we could incorporate the company under the name of our choice. There are a lot of rules about names which surprised me. Obviously, you can't use a name which might cause offence to people, and you can't use a name that an existing company has, or one that's very similar to it. There are also some words that you have to get special permission to use in a company's name, such as English. I wanted to make sure that we could use the name as a domain name on the internet as well as using it as the company name. We wanted to call it Executive Art, but when I did an online company's house search to see if the name was available, it wasn't. We finally chose Exclusive Art Limited. Anyway, our solicitor asked us a lot of questions and drew out a number of documents, including the Memorandum and Articles of Association. My wife Judith and I are the only shareholders, and we are both directors of the company. We had to appoint a company secretary too, and luckily for me, Judith's friend agreed to be our company secretary. She's a lawyer, although she doesn't practice now, as she has 2 young children. We had to decide on the amount of capital that the company has. There are 2 different capital values, the authorised share capital and the issued share capital. I've learned a lot in setting this company up. Basically, the authorised share capital is the total nominal value of shares that the company is allowed to issue, and the issued share capital is the amount the company actually does issue. I think that's right. Our lawyer advised us on the amounts. Then we had to choose a registered office. We just use our home address. Obviously, if we rent an office, which I think we will do soon, we might change the address of the registered office. The other document which our lawyer drafted for us, the Articles of Association, contains all the rules and regulations of the company. It covers things like company meetings, notice periods, directors' payments, issuing shares and so on. It's pretty complicated, and to be honest I started to read it but soon gave up because it is so complicated. But our solicitor ran through the most important points with us. We had to pay a fee to register the company, and 2 weeks after we sent all the documents to Companies House, we received the certificate of incorporation. That was 4 months ago. We've already got 2 good orders from some big customers. I know it's not going to be easy, but it's an exciting time for us.
Unit 9B, the language of company law. Unit Listening.
Good morning, ladies and gentlemen. Thank you for coming to this seminar. This morning's topic is the role of company directors following the recent introduction of new legislation. This affects all companies in the United Kingdom. The role and duty of directors has developed over the years from case law and statute. You are all aware of the fiduciary duty of the director to the company. Directors have this fiduciary duty because they are in a position of trust and confidence in relation to the company. Directors have a general obligation to act in good faith and in the best interests of the company, and not for any improper purpose. They mustn't, for example, make a secret profit out of their position. A director's duties were not clearly stated in statute until 2006. However, following the Companies Act 2006, there is now a statutory statement of directors' duties. This was done so that the law is made clear for directors. The codified duties are contained in sections 170 to 177 of the Act. Section 170 makes it clear that the duties of a director are owed to the company, and therefore generally only the company can enforce them. The Act then lists 7 specific duties. The first duty is the duty of a director to act within the company's constitution and only exercise powers for the purpose for which they are intended. The second duty, found in section 172, is the duty to promote the success of the company for the benefit of its members as a whole. This new duty broadly replaces the common law fiduciary duty to act in the best interests of the company that I mentioned earlier. In fulfilling the duty to promote the success of the company, the Act says that the directors must have regard to a long list of specific factors. These include the likely long-term consequence of any decision, the interests of the company's employees, the company's business relationships with suppliers, customers, and others, the impact of the company's operations on their community, and the environment, and so on. There was considerable criticism of this new duty, with people expressing fears that directors will be more defensive in their actions. This is because directors must consider this long list of factors with every action they take. Time will tell whether this happens or not. The third duty is to exercise independent judgment, while Section 174 deals with the fourth duty, which is to exercise reasonable care, skill, and diligence. An important factor to consider in this area is the individual director's level of specialist knowledge. The common law principles are now clear. Directors who have specialist knowledge must exercise greater care and skill than those who do not have this particular knowledge. Similarly, different skills would be expected of, say, a finance director and a personnel director. Section 175 provides for the fifth duty, which is to avoid conflicts of interest. A director must avoid a situation in which he or she has or can have a direct or indirect interest that conflicts or possibly may conflict with the interest of the company. This duty is not infringed, however, if the matter has been authorized by independent directors, so long as the director in question does not form part of the quorum making the decision. For those of you from companies having 2 directors with a quorum requirement of 2, be careful. The sixth duty is not to accept benefits, including bribes, from third parties, while the final duty is the duty in Section 177 for a director to declare his or her interest in a proposed transaction before the transaction is entered into. If a director breaches this duty, he or she commits an offence, which may result in a fine. I've prepared a fact sheet for you summarising your duties as a director under the new legislation, which you can take before you go. Now, are there any questions about what I've mentioned before we move on to the next point?
Exam exercise listening.
Hello and welcome to the Banking and Insolvency Department. My name is Kim Watts and I'm very pleased to meet you all. This is quite a large department, doing a lot of varied work. I specialise in insolvency. Most of our clients are either banks or companies. The banks have generally made a large loan to a company, often secured by a debenture, and now the company is failing to make its repayments on the loan because it is in financial difficulties. The bank instructs us to assist with the recovery of the debt. Our other clients represent the other side of the coin. They are companies who are facing insolvency, and they come to us for advice on the best way forward. The most common description of insolvency is that a company cannot pay its debts when they become due. There are various insolvency procedures that are available to companies. I'd like now to briefly outline these procedures, as they often cause confusion until you become more familiar with them. First is the compulsory liquidation of a company. This is when the court orders the company to be wound up. Winding up usually starts by a creditor making a petition on the grounds that the company cannot pay its debts. The official receiver, who is an officer of the court, becomes the liquidator of the company, and he or she has a duty to investigate the company's affairs and the causes of its failure, including the conduct of the directors. A director can be disqualified from acting as a director for a period of time if, for example, he or she made the position of the creditors worse by continuing to trade when the company was insolvent. When the winding up is complete, the company is formally dissolved and it no longer exists. Next is administration. This is a court order made to appoint an administrator to manage the company's affairs. A court may make an administration order when the company is unable to pay its debts, and the court considers that by making an administration order, the whole or part of the company may be saved as a going concern. The company, its directors, or its creditors start the procedure by making a petition against the company. While an administration order is in force, the company cannot be wound up and legal proceedings against the company cannot be started except with the approval of the court. The administrator takes control of all the property of the company and makes proposals for the creditors to consider. The administration order continues until the court decides that the order is no longer needed and formally discharges it. Another insolvency procedure is receivership or administrative receivership. A receiver is appointed by the holder of a debenture of the company secured by a floating charge. Usually this is a bank. The company is said to be in receivership. The receiver has the power to sell the assets covered by the floating charge and give the proceeds to the charge holder. A further procedure is a company voluntary arrangement. We call this a CVA. This is when a company makes an agreement with its creditors in order to settle its debts over an agreed period of time. The agreement has to be approved by the court. Meetings of the company and creditors are called to approve the proposed arrangement. Once approved, all creditors who had notice of the meeting and were entitled to vote are bound by the terms of the arrangement. The company can continue trading during the CVA and afterwards. Finally, there are two types of voluntary liquidation. Members' voluntary liquidation means that the directors have made a statutory declaration of solvency. In other words, the directors believe that a company is solvent. This happens when a family business is sold off, for example, or if the purposes of the company have come to an end. The liquidation starts when the members, in a general meeting, pass a resolution to wind up the company voluntarily. Remember, if it is a voluntary liquidation, the company is not insolvent. In the case of a creditor's voluntary liquidation, the company cannot pay its debts. The process is started by the directors, not the creditors. The company carries an extraordinary resolution to say that it cannot continue in business because of its liabilities and that it is advisable to wind up. A liquidator is appointed to wind up the company's affairs. The liquidator does this by realising the company's assets and paying its creditors. If anything is left over, the members of the company receive it. In both types of voluntary liquidation, when the company's affairs are fully wound up, the formal dissolution of the company occurs and it ceases to exist. Well, I hope that this helps just a little. I'm sure that you will gain some experience of all these procedures during your 6-month period with this department. We have a great team here and everyone will be very happy to answer any questions you have, so please feel free to come to any of us at any time.